Okay, good morning. This meeting is being conducted pursuant to the New York State Open Meetings Law, Public Officers Law, Section 100 et sec. For purposes of this meeting, I'm designating Julia Lee as recording secretary. And today we have before us consideration of two matters. First, proposed amendments to Title 53 of the Rules of the City of New York, Board Rule Chapter 2. And second, proposed amendments to Title 53 of the Rules of the City of New York, Board Rule Section 1-14. Catherine, why don't you give us a brief opening, kind of set the stage for the discussion of the amendments to Chapter 2, and then we'll just open into general discussion.
Sure. So Chapter 2 of the Board Rules contains the procedural rules for enforcement actions brought by the Board. We propose amending the rules in their entirety to update these procedural rules and provide clearer guidance about the Board's enforcement process. The current rules were adopted over 2 decades ago, and since then, the Board has gained substantial experience adjudicating violations of Chapter 68 and has utilized additional procedures that extend beyond those initially envisioned by the Board. So these proposed revisions aim to address 3 primary goals. The first being to codify and clarify the Board's current enforcement process. The second being to eliminate provisions that are redundant or no longer relevant to the Board's process. And 3, to improve the Board's current process by implementing some more structure around the current guidelines.
So I'm going to suggest that we open with any general questions, comments, or concerns, and then let's say page by page, we can just sort of page through it and see as individual things come up.
Yeah, I just had one general question.
Okay, yeah.
So we're basically replacing the whole chapter.
Yes.
Okay. So what were the redundant provisions or the no longer relevant provisions from the old chapter that are no longer being contained, no longer included in the new revised chapter?
So we've removed language that was redundant of Chapter 68. Occasionally there was a lot of repeat of language that was already covered within this Chapter 68 statute. But the other big change is that when the rules were drafted, it was envisioned that that hearings of the Board might be conducted by the Board itself or by the Office of Administrative Trials and Hearings. Over the years, the Board has come to exclusively rely on the professional, experience of administrative law judges at oath. And so the big changes to these rules are to remove any references to the Board's holding of hearings, because oath has its own set of procedural rules that we rely on once a action is commenced at oath. So those are the big
Yeah, I understood that was the big
non-relevant
change, but is
yeah.
there any like minor ministerial things that we should be aware of? Because when I looked at when you look at the old Chapter 2, it's organized completely differently, and I started going through it and spot checked, and it looked like most of the important stuff was included in the revised chapter, but I was just curious if there's anything else other than the big picture items that dropped out.
Other items would include methods of service. There was the current rules have a lot of follow the rules of civil procedure for options of methods of service, but we consistently serve our documents first class mail, so we've just focused on that method of service. That's one of the examples, but mostly we've gone through and made sure that we've preserved any parts of the rules that we do use in our current procedures.
They've just been reorganized.
They've just been reorganized, yes. So the big reorganization here is that the Board generally, an enforcement process through the Board takes place kind of on 2 tracks. So a respondent always has two opportunities to respond to and potentially resolve enforcement action brought by the Board. The informal process, where there's a notice of probable cause served and they have an opportunity to respond, and then we might come to the Board to request that it be sustained. And then if it is sustained, to go to the formal proceedings at oath. And because that informal process is a lot of our big part of our enforcement practice, we wanted to make it clear that those are two parts of the process of the Board.
Thank you.
Elaborate on the settlement process as well.
Thank you.
One general comment, and it's not a change from the old chapter. I don't see, we don't make any reference to private warning letters. And is that because they're not considered enforcement anymore? They're not considered penalties? They're not governed by this? I mean, I was just, having read our annual report, which talks about them, I'm just wondering, what's the rationale for making no reference at all?
It's not part of the enforcement process. I
Okay.
think that's the logic of it. There's nothing in the charter that talks about, there's no finding by the board of a violation. There's no due process that is connected to a private warning letter. It's essentially unsolicited advice. So it didn't seem like
Okay.
it was part of this process.
Is it always unsolicited advice? I mean, sometimes matter comes before us, consider it, and we say, well, let's not enforce it, let's write a private warning letter.
Yeah, what I mean to say is advice someone always asks for, no one asks for a private warning letter. So
I understand that, but just to pick up on Richard's point, because that is one of the possible outcomes of an enforcement proceeding, or at least a complaint. Shouldn't it be in our rules that people will know that that is one possibility, the public will know?
It also might help because it's a private warning and we don't, and there's no, if someone made a complaint, you know, some of my superior selling Girl Scout cookies, if we ended up, for whatever reason, issuing a private warning letter, we found, well, she wasn't selling the cookies, there was something else happening, you'd never know as the complainant that anything happened. But at least if you know there's, I guess, possibilities of disposition, you could surmise that maybe nothing, or maybe there was a private warning. Just thinking, it lets people know what are all the possible dispositions that could happen. But then I guess you'd have to put, I mean, dismissal is referenced too. So.
Right.
Again, dismissal's in the charter.
Right.
The private warning letter is something
We
the
just
board
made it up.
cooked,
Right.
is an extra process that the board wants to be able to address things. It's not, there's no.
Right, to try to avoid any possible further
Right.
violations.
I mean, it's sort of
Yeah.
it's sort of a gap between, when we look at matters, we think of that as one of the options.
Right.
As an enforcement option, even though it's technically not an enforcement action because we haven't brought a
We don't.
complaint. So it's not, it's sort of in and not in, and I was just sort of wondering whether, on the one hand, for completeness, we might want to make a reference to it, although it's not clear we want to have any we want to limit ourselves to procedures for doing it. So one possibility would be to put it in the commentary, but not in the rules, as something that, you know, is one of the things that the board does, but that because it's, it doesn't involve, literally does not involve enforcement, we don't think we're not gonna put it in the procedures. I mean, I could see a case for not mentioning it at all because there are no consequences, and these procedures are about making sure, letting everyone know the procedures that exist for when there are consequences. On the other hand, we do treat it as part of our toolkit.
Right, and just in the overarching purpose of providing greater clarity and
Yeah.
notice. And we do mention, obviously, we have public warning letters, so.
Right.
We could maybe, I like the idea of mentioning in the commentary and saying, talking about what a
Since it's
private
not
warning
part of
letter
the
is,
process.
and distinguishing it from a public warning, and maybe just leave it at that, and not include it in the rules.
And maybe just say why it's not in the rules, because it is private, and it has no consequences.
Exactly.
And it doesn't involve any process with person warned. I don't know any language I want to put out there now, but it just, we can come back to that at the end, but just as a thought.
And I wouldn't say no consequence, because certainly if you've received
Right.
a private warning letter and then down the road you're engaged in the same conduct, we would
Right.
take that into account when we're deciding whether.
I would say just as we would any other indication that you were on notice.
Right.
Right, that
Right.
you had
So it's
clearly been
noticed,
advised about
right.
this. So if we had, outside of the so-called private warning letters, if we know that you have been, that you're on
You called up
specific notice
COIB,
about.
right, and you got the advice and you still
Right.
didn't follow it.
Exactly.
Right.
I would still consider putting it in the rules, especially because it's not in the charter and it's something we have created. Maybe there should be some legal basis for it, some stated basis. Maybe easier just to state it as a possible outcome and explain in the commentary why it is we're not stating it. So I don't know that it's harmful. So much of our practice revolves around that, as is reflected in the reports. So let's think about that.
I guess my only concern about putting it in the rules, or at least putting it here, is whether or not at that point that begins to sort of generate some claims for a more formal process on the part of the person warned. He says, I got a warning letter, and said, well, I didn't get a chance to I didn't get any process on it beforehand, and our view is there really shouldn't be any process, this is just a private warning letter.
Right.
So I'd be a little, I mean, I could see the case for not mentioning it at all. I could see the case for mentioning it in kind of commentary, but not in the rules. I'm a little nervous about
I
putting
would
it in the
support
rule
that,
itself.
putting it, it's, because it is outside of the process, it's not. Also, I guess we could also, if it's added in, you know, to the actual rule, you could see people saying, I want a private warning letter, I
Right.
don't want a disposition,
Yeah.
I want a private warning letter, and that's not really what it is, it's not that kind of an outcome.
Right, it's just a letter from
Right.
the board. It doesn't
Right.
say private warning letter
Right.
on it.
No,
It's just,
right.
as Carolyn described it, it really is just unsolicited advice. The board became aware of something and is just letting somebody know, hey, here's what the
You're
law
close
says
to
on
the
this
edge
subject,
of
and here's
the-
where the line
Right,
is.
we
Yeah,
some-
you're close to the.
Sometimes we say we don't know the facts for enough, so sometimes we say, probably was a violation, but it's very minor. I mean, there are various, multiple versions, those two come to mind right away, where we're just uncertain what the facts are. And sometimes we think it's likely there was a violation, but it's extremely minor. There may be other circumstances that are not immediately coming to mind.
Sure, like we are aware of conduct of yours that would require a waiver, please contact
Yeah.
us.
Yeah,
to
that's
ask
right.
for
Oh,
a
you'll have a
waiver.
chance to get in.
Right, you've
That's
already
right.
been disciplined by your agency.
Right,
We
or
want you to
sometimes
know about
it,
this.
right, or sometimes it comes out with, something shows up in a disclosure report.
Right.
Where they should get it, they should have asked for a waiver, and we sort of sent them a notice.
Exactly, it's a very wide variety of things. It really is just a letter from the board to a public servant, you know, advising them of what the law requires and saying what they ought to do or be aware of. It feels informal enough to me that it doesn't merit inclusion in the rule. But I think including some mention of it in the commentary is not a bad idea.
Indeed, I wouldn't even call it capital P, capital W,
Yeah,
capital
little
L.
p, little
I would include things like,
I was thinking
include a
that.
letter, an informal letter or advice or something, or words to that effect. I would not capitalize it, I would not
It's not a
formalize it.
thing, right,
But
that
just
people
indicate
would
that
request.
it may also be the case that one of the other things that we do is that in an appropriate setting, we don't bring a formal action, we might send a letter to a person advising them of that they've engaged in conduct that is relevant to the charter and they should be aware of it, or some, I'm not writing, this is not meant to be text now, but something like that.
I'm convinced.
Okay. Anything else general before we sort of page or section through?
Not general.
Okay, okay.
I don't know if the concept of discovery in the informal
Mhm.
process, there is obviously, it's mentioned in there, but it's also in the commentary, so I don't know if that's a broader,
Oh, we
general
can
point, or
just-
we
just-
address it when
you
we
made
get
it.
to
You know,
it.
it's in, let's talk
Right,
about it.
right.
Okay.
Just because I don't know, how does it work? It seems that there's some information provided to help facilitate settlements, but that's not, I guess that's short of a formal discovery. I don't know how that works, but I do get the sense that there's some information that's shared in terms of here's what we believe happened and here's why we believe it, and that helps to generate a settlement. So the broad statement that this will not be considered, I don't know if that's overstating what actually happens. I don't know if that's purposeful to, or if you think that would help or hinder settlements outside of oath.
It's, you know, public servants can provide to the board really any documents they want as part of their what's called the response in the informal stage. You know, if they feel like there's some document that would explain to the board that this is all a big mistake and the board should close this matter, public servants can certainly do that. But as far as formal discovery proceedings whereby, you know, they can require us to provide certain documents and we can require them to provide certain documents, doing that under the.
Well, I'm saying something short of that. It is the sense that, no, we're not gonna tell you at all what we have. You have the notice of what we believe the violations were, and that's it. Or is there, and I'm saying in practice, is there an actual bit more of a give and take in terms of, well, we think here's what happened because of X, Y, Z, but no, we're not gonna
Yeah,
provide.
we're using the term discovery in the litigation
formal
context, where we're thinking like you're serving us with a demand and we're
And we're gonna
responding.
give you all
But we're
the
certainly
documents.
saying, Yeah, I've listened to your interview with DOI and I know you said X.
Right,
We're
right,
not
which is
providing you
helpful
the
to,
interview.
yeah, okay,
Right.
okay. So that's true.
Okay, let's, as long as we're in, let's keep going in. I kind of recommend that we go on the, based on page turning, or you can call them
Page,
sections, but,
Start
Are
with
we gonna
I guess.
11?
start at,
Yeah,
11,
one.
exhibit 1?
Yeah, let's start with page 11, unless anybody has any specific comments on the specific language of the commentary, which I would go to. Why don't we take a moment if anybody has any, exactly any, the specific language of the commentary. Otherwise, I think we can move directly to page 11.
Just the discovery thing.
Yeah.
Um,
Yeah, I didn't have any.
So, okay, so I'm now on page 13, because I have one comment.
Page 12?
Page 12, go ahead. All right. I feel like I'm at the
No,
fish
I'm
counter at
13.
Zabar's trying to move the
Yeah.
line along.
In I guess, paragraph 5, paragraph is, where on the fourth line, when we talk about an organization affiliated with the elected official, shouldn't it be also an officer, an organization or an officer or employee of the organization? Is it, I mean, the respondent could be more than just the organization, right? It could be an individual we go after.
So, yeah, this is
There's
on,
an agent of an elected official.
this is on
Yeah,
line
the four-
12
Or
of
an
page 12.
officers.
Yeah,
Okay. Right.
should it be an
No,
organization?
the respondent is the organization.
Is it always the organization?
Yeah, that's what the law provides for the penalty to the organization or to the affiliated elected
But
official.
not the, yeah. And then I guess on line 13, where it says an agent of an elected official, should it say an elected official or agent of an elected official?
What line are you at, Jeff?
The next
13, line
13.
13. on
The
page
tail end of
12.
13
Yeah.
carrying over to 14.
Okay.
And I'm sorry, your question about.
Should it say, instead of saying just an agent of an elected official, should it say an elected official or agent of an elected official?
Jeff, they would already be covered by public servant in line 10.
That's possible. I mean, I realize that.
Right, that's trying to
Yeah.
capture a different category of person. That's your former campaign manager. That's a part of the affiliated not-for-profit law that suggests, if that person starts a not-for-profit that collects donations and the elected official still controls it.
But it could be the elected official.
It could, but that person's a public servant.
So that's covered in the first
Yeah.
3 lines
Right,
already.
yeah.
Okay, if we're comfortable with that. Okay,
On the next page, page 13, in the response on lines 5 and 6, where the response, after we explain, rebut, or provide information, I'm wondering whether you should also say something about or make a contention with respect to the misapplication of law, because in the commentary, it says that's one of the things a respondent can do. On page 5, it's 10 and 11, 12, it says that the respondent believes the board has misapplied the applicable law, the respondent can present those arguments in response. So I would insert that there too. Just to match up the commentary and the rule itself.
How about,
Again, I'm not giving text, but the idea of.
how about concerning the factual or legal allegations in the notice?
However it matches up best with whichever
Okay,
the comment, I mean, you can change the
okay, so, yeah.
commentary also, but it seems to me at this point, the commentary and the rules should match.
Yep.
And especially if there is a right to argue that, I didn't violate the law because the facts didn't match the law, right?
Yeah, will do.
Okay. On page 14, could you just explain what the phrase on line 4 means? Respondent with disciplinary rights as described in chapter 2603H2. I wrote in the margin, what is this?
Yes, so city charter
It's like a
section
union,
2603H2 states that if the board sustains its finding of probable cause, that, and the public servant is subject to a collective bargaining agreement under which they are entitled to disciplinary rights, that it would be referred back to the agency for their opportunity to engage in that disciplinary process.
Okay. And then, let's say a little bit further down on line 11 of that same page, which says if the board's unable to resolve with the agency, the board may commence formal proceeding against the agency upon conclusion of the agency's disciplinary action. Does this mean we always have to wait till they're done? That we always go second? Is it possible we would go simultaneously? That implies that we can't start until the agency is finished. Is that
Don't
our
we usually
process?
wait? Yeah.
Well, I mean, are we obligated? I mean, as opposed to custom, is it, we're now binding ourselves to waiting until they're done. Is that what we want? Okay, just clarify.
Okay.
Yeah.
Thought process-wise,
Right.
that's just efficient, because depending
Yeah.
on what their resolution is, if it's termination, I feel like that often impacts what we do next.
It's just the difference
Right.
between normally deferring and basically this, I think, requires us to wait. I'm not just clarifying.
Right.
Right, this would just be codifying our practice
Okay.
of deferring, but
Okay.
Could you say the
Not
board
required
may
to.
defer commencement of formal proceedings until after?
We always have.
I guess to
Yeah.
Richard's point, in case there's ever some instance where we might ever want to duplicate the agency's efforts at the same time the agency.
I mean, I just was wondering whether, why we would absolutely bind ourselves, even if it is our custom 100% of the time.
We may not be happy with what the board is doing. We may have our suspicions of people conducting the enforcement proceeding.
Or what if they're just being very
Well, then they can
dilatory?
just- yeah.
What if we conclude that they're being excessively dilatory by our standards?
Which would,
I don't have text again, but I'm obviously willing in 99% of the cases, maybe even 100% of the cases, to let the agency finish up, but I'm a little reluctant to
Well,
bind
you
ourselves.
reserve the
Yeah,
ability.
yeah. So think about some way of finessing that would indicate that we're normally gonna wait, but that we're not absolutely bound. Maybe Jeff's language was the right language. I'm a little reluctant to draft in public, because I haven't thought through the ramifications of all the words. On the next page, just a quick question about, talking about lawyers are gonna be bound by the New York Rules of Professional Conduct. What if it's not a New York lawyer? Just the earlier sentences say it could be somebody who's admitted anywhere.
I
Yeah.
highlighted that as well, because it seems that we're posing some restriction on, there are already rules, however they exist, of how an attorney can withdraw. So it's interesting that we would add that.
I mean, I'm not against it, but it's more like it's having neatly before said it could be anybody, or it could be admitted anywhere. Maybe it makes sense to have one set of rules, so maybe I'm not against it, just want to talk.
Or
like
say
that.
subject to, it just seems odd for us to decide how an attorney.
Well, we should, we have to. There's no applicable rule.
No, if you're an attorney, there are already
Well,
rules of how you can withdraw from
ethical rules.
representation.
You have
Right.
ethical rules, and then each jurisdiction may have their own rules.
So we're just referring back
We're
to a
using-
particular jurisdiction's ethical rule.
Right.
And this rule is preserving one of the current rules in Chapter 2, and is also
Which
here-
says that.
It's essentially, I guess, along the same lines. And the other purpose of keeping this here is to provide guidance to respondents and their attorneys so they can pick up Chapter 2 and understand that we can point them to this if they are looking to withdraw from a case, and they can follow the guidance provided here.
And that was in the old rule.
And this is in the
Right.
old rule.
So we've already been
So
doing
it's,
it.
I can say,
Yeah.
having worked at a couple of different federal government agencies that have some litigation authorities, they have their own rules for this as well.
Yeah.
So it's, I think, fairly common that government agencies set forth rules for this kind of thing.
Right, I see we're using that we're adopting that as our rules, basically. We're providing notice as to what it is.
okay, that's fine with me. Next page, page 16, line 5. This is a really minor quibble. maybe it's develop a minor, I don't know. Public warning letter should include statement of facts as understood by the board. That seems sort of internal almost. I was wondering whether, the point is whether it's agreed to with the board. In other words, the idea is it's not just the board's understanding, we want a commitment from the respondent. I don't know that it changes it, but I was going to suggest changing as understood by the board to as agreed to with the board. Unless I'm losing something, missing something, or changing something that I'm not seeing.
Well, the structure of a public warning letter is a little different than a disposition, where a
Okay.
disposition is framed
Oh, okay.
as.
No, keep going.
Okay.
The light bulb just went on, but why don't you finish the sentence? Now I get it, but why don't you finish
Right,
the
where the
sentence?
respondent is admitting to facts, and
Yes,
those facts
okay.
are very aggressively
Got it.
negotiated. And in
Got
the
it.
public warning letter context, it's really a letter from the board saying, and the letter is framed as the board, as the facts, and you've agreed to make this
Right.
public. And part of the structure of that document is like, oh, the person's not admitting to these facts, they're just agreeing to allow the board to make these facts public.
Got it, light bulb on, this
So,
this seems fine to me.
I had a comment before that, and it relates
Okay.
to the same
Okay.
concept, and it's on page 15, line, I guess it's the line 19 to, no, I'd say line 20, 21. So page 15, line 20, 21. The way it's worded makes it seem that the settlement agreement is one of these two things, the public disposition or a public warning letter. Whereas it's not, its settlement agreement is the public disposition, or it could be something that's not a settlement agreement, it's a public warning letter.
That is a settlement agreement, the public warning letter settles the case. It's an
But it
agreement to
doesn't-
settle the case.
But the settlement agreement is negotiated, right, and
So is a public warning letter.
so it's just, it won't have an admission if it's the public warning.
That's right.
And we decide what the actual, well, it's not
Well, we
really
still
negotiated,
negotiate
we're deciding what the.
We still.
It is negotiated, it's just that the document ends in the form of a document where the respondent makes no admissions.
Right.
Right, the respondent just signs saying that they agree to make it public. And that's really the distinction.
And this is, we're saying X, Y, Z happened, we're saying this is what
Right.
happened versus
Right.
how the public disposition starts off.
Right.
It's not, I understand
You
why
know
you're
what
trouble,
I'm
it's
saying.
not a settlement agreement in
It's
the
not a
classic
settlement agreement,
sense,
right,
but it's an agreement that settles the matter.
it resolved, yeah. I
Basically.
know.
You understand?
Right,
Yeah.
it's a
Right, but it is a
resolution.
negotiated
Yeah,
document.
it is, and
Right.
they signed it.
But
They-
not
they
to the
agreed
same
to it.
degree, I guess.
Yeah.
It just,
They
Well,
agree,
they've agreed
they have
to
to
it.
agree.
right.
Because we do negotiate the language.
Right.
But it's just the
I don't want to
framing
phrase
is-
this way, I want to phrase that way,
That's
those
exactly
kinds of things, okay, okay.
Okay, and it's important to keep it that way because of on the next page, the section that begins with line 8, that is intended to cover both.
Right.
I was
Right,
wondering whether
yes.
in response
Yeah,
to
that's
Erica's
what I was,
point,
yeah.
Right.
we would change maybe resolved by settlement agreement, public disposition, or by a public warning letter, and then that would ruin the effect of 2 on the next page, because 2 is really designed to, by using the language of proposed settlement agreement, to cover both.
Right.
Okay, so we leave it,
Yeah.
yeah. More on pages 16, 17.
On 17, you say the files of the enforcement action will remain.
Jeff, what
What
line
line are you on, Jeff?
Or what
I'm
section?
on 4.
4, okay.
and 5. I guess we repeat it again on page 21. Will the underlying documents always be confidential? I mean, on 21, I think on page
Yes.
21, we said we would release the DOI, the underlying
The,
report.
the files would always remain confidential. The only thing that might become public is the report and recommendation from the oath
The
judge,
oath judge.
which is attached to the board's final order.
But should the underlying documents always be confidential?
Yes.
I think they might actually be required to be
Well,
confidential.
that's another question, if they're
Yeah.
required, but.
The city charter under 2603K, if I've got that said right, requires essentially all the board's documents to be confidential,
Hold on.
with the exception of a small number of specifically enumerated documents. The final document ending an enforcement case is one of those documents, but the other documents about that enforcement case would not be.
So the confidentiality requirement then goes beyond requests for advice.
Yes.
It does, it describes all documents and
Yes.
records of the Conflicts of Interest Board. It's a very broad confidentiality requirement.
Because you would think in some circumstances, there might be submissions by the respondent that we might at some point feel should be made public. In some submission, but that's
Well, I
not-
mean, if there's a submission
Factual.
from a respondent that bears on the outcome of the case, that would almost certainly be described in the report and recommendation or board order if it went to oath, or the settlement disposition or any kind of settlement agreement.
Yeah, but in response to a later question, for example, from a third party, as to why the board did X, we could not point to a falsehood in the submission, for example, if we say everything must be kept confidential.
I just wanted to point out, in our disposition agreements, we do have a provision in there that says if the respondent denies any material facts in the disposition, that they waive confidentiality. So at least in that circumstance where things are being said that are untrue about a disposition, we can.
You mean in a later instance, if they come forward and then say, no, this didn't really happen?
Right,
That's
they
a
do-
waiver
they do
of
like
confidence,
some-
okay.
On occasion, they do really do that, and so that's why we have
to your
that.
point,
Yeah,
if it's a later
that covers
date.
one side of it,
Right.
but if somebody questions, why did the board do what the board did?
They question that all the time.
No, question that, and we, we could not say, well, we relied on this statement or this submission of facts.
That's right.
I think
We
that is
can't.
right.
We can't, well, we
We
can't do
cannot,
that.
we cannot.
Cannot, well.
We cannot and never have. And even the provision that Michelle is citing that is in the dispositions as like a prophylactic thing, we've also never done that. Released
But
otherwise
that's
confidential
different
facts.
than the respondent making that claim. I think what you're saying is if some third
Some
party.
third party, the press.
Which happens, that
investigator,
that happens
Yeah,
all the time when we get
Right.
criticized, but we're hampered, we can't say.
Well, that's the question, I know,
Right,
we are
yeah.
hampered,
Yeah.
and if we have to be hampered by statute, then we're hampered. But if we're doing it to ourselves, I just question it.
Right. Right, I think that as a practical matter, it is more helpful than harmful because, it protects the integrity of the institution to not engage in those.
You go down the rabbit hole once you start.
Yeah,
And
that's
then
right.
everybody now gets to micromanage, and why didn't you disclose in this case, but you did in that one?
Right.
And also, the basics of negotiating, the settlement is crafting something that everyone can live with the statement of facts, and so the respondent also should have the comfort of knowing that these are the set of facts that are going out to the public, and then we're not going to relitigate it after they've already agreed to.
Oh, okay, so I think we were on, 17, sorry.
17?
18.
I have a question with on 19, on the hearing, subsection F. So 203, formal proceedings, if you go back to A, it says that oath is going to conduct the hearings in accordance with the oath rules, except as otherwise provided by these rules. So we go to H, and H is the hearing, and then we're going through like the rules of
F,
evidence.
F.
I mean F, sorry. Section F, that goes through basically the rules applicable at the hearing. So the first one that struck me is in F1, where we have all offers of settlement will be confidential and inadmissible at the hearing. What does that mean? Does that mean everything that was provided in the context of the settlement, or just the financial numbers, or the penalty? It seems both maybe too broad or too narrow. I just don't know exactly what that means, because it's not like a 408 Federal Rules of Evidence, which precludes certain types of information that was provided in the settlement context.
And this provision is also preserving
What we had before.
something in the current
Okay.
rules.
So how have we done it in practice?
Right,
Yeah,
so
do
oath
we-
is very rigorous about having, unlike, federal court, where it's the same judge who you try to settle the case with and who tries the case. In oath, you have a different judge, a settlement judge and a trial judge. And so there should be no discussion of whether who was tough about settling, who refused to settle, what the numbers were, nothing about what anybody made representations. If one of the parties made representations about what the facts were in the settlement conference, none of that comes into the hearing.
So should it be broader than all offers of settlement? Because that suggests to me that the only thing that's precluded and confidential is what the other side or what we offered to settle the matter. And what you're talking about is something much broader, which I agree with, and it makes
Right.
sense, and is consistent with my recollection of how we do it.
Something like any matters relating to settlement, to a discussion of settlement or something?
Any
Yep.
settlement
Well, it's the
discussions or information
negotiation.
exchanged during settlement discussions?
Yeah, I mean, you don't want to
Yeah.
prevent people from being able to provide the same documents that they provided. It's really just because the evidence still has to be provided at the hearing. So I think what we're really focused on is, primarily what were the parameters of an agreement for resolving the case, like that piece of it. And I'm not, I can imagine maybe there's other language for it, but to me that sounds like an offer of a settlement, like whatever the enforcement attorney offered as far as dollar amounts or language in a disposition or willingness to drop certain charges or something like that. Those pieces, the pieces that are about an offer of a settlement, that's the part that we wouldn't want to come into a hearing because we want that sort of frank discussion to be able to happen in the case conference.
But facts that are disclosed during the settlement process, those can be admitted at the oath.
Well, you still need testimony.
Right.
I think it's more like, well, if I'm making an argument, he was willing to admit that he did this. This is not like he's claiming now, but 2 weeks ago
He
said
told us he did it and he was agreeing if we could
Right.
reduce the fine to
And
500.
he testified if the
But that's
respondent.
offers and admissions. It is broader than the language, but then
Yeah.
at the same time, the language is, it's unclear. What does that mean?
Right.
Is it offers and admissions in
Yeah, maybe
connection with
maybe
settlement
that's it.
negotiations?
Yeah.
It's something like that.
Maybe-
Yeah, we'll see if we can come up with something that's a little broader.
Okay. Maybe take a look at 408 and see
Okay.
how that's precisely framed, because that goes exactly to where you're going.
Right.
You
Okay.
can't,
You wanna
you
have
can't
the facts.
use any statement in connection with settlement about your liability as proof of liability.
Yep.
Okay. And then the other mechanical question is with F3, enforcement attorney will initiate the presentation of evidence. I guess, doesn't oath have its own evidentiary rules?
Here's my question too, are these our rules or oaths?
These are our rules. Interestingly, the oath rules of practice doesn't outline it so clearly, so we
But they're
thought it would
consistent
be,
with the oath.
yes, it's consistent with the practice of that oath.
Right, it's consistent with the practice, the oath rules don't speak to this
This.
Of
explicitly.
who goes first.
Of
or
who
Yeah.
goes
has-
first, this is what happens, but you couldn't look at the oath rules and
Who
figure out
has the
what.
burden of proof?
Yes,
All
Yeah.
that.
It's that they follow the traditional.
Right.
Yeah.
Because I
process.
read the
So-
preface of this section was, the hearing's gonna follow oath rules, except for how we may depart
Specifics.
or provide greater clarity in this rule. So, in the context of providing clarity to people who are gonna be hearing these hearings, what are the applicable rules of evidence in the oath hearing? I know they're very relaxed, I know it's not the federal rules of evidence, but what are the rules of evidence that are applicable? Because we're saying the enforcement attorney can present evidence, but what are the applicable rules?
It's just that hearsay is
Is there-
admissible, that's the only explicit oath rule about evidence.
Okay, so oath
And then you have to provide you have to provide copies to people, that kind of sort
Okay.
of logistic stuff.
but oath has an existing rule that applies to that,
On the evidence piece, yes.
on the evidence piece. Okay, all right, that was my question.
Yeah.
All right. Jeff, is that where you were going as
Yeah,
well?
I just wanted,
Right, but the actual, you couldn't look at the oath rules and figure out what's gonna happen when you walk into the room, that was the significance in this.
Got it.
Uh-huh.
But you know that hearsay is admissible.
Right.
And there's certain rules that are applicable to that. Got it. Okay, thank you.
Still 19, go ahead.
on the page before, we talk about the wall between the enforcing attorney and the counseling attorney. It's
Jeff, could you be a little
fine.
louder? I'm having trouble.
Yeah,
hearing you.
on page 18, starting on line 6, the
Mhm.
communications, I think having a wall between the two sides is a good idea. But we say there's an exception, and one of them is at the request of the board or the attorney serving as counsel, there can be discussion, if necessary. Do we ever say if if the board or attorney serving as counsel deems it necessary. There's no standard of what is necessary to reach that wall. So we could say, if deemed necessary by an attorney serving as counsel or the board. So making it clear it's our determination.
Okay.
And not an objective standard that somebody can question.
So it sounds like the very final words of 15 and 16 would just be,
Yeah.
so if the board determines it to be necessary.
Yeah, if the
Yeah, just
council or
making
the
it sort
board
of,
determines it.
who's deciding
Saying what
necessary?
Yeah.
is necessary,
Right,
so
yeah.
who decides that.
Right, who's deciding it's necessary? Okay.
Exactly.
That's, so that was 18, back to 19, 20. I only had one question on the
Yeah,
comments
yeah.
on 20.
Uh,
The 30-day deadline thing. What happens if somebody's initial comment is late and we take it? Would we want to give ourselves more time to respond and vice versa? I was wondering about 30 days from the oath report, or the later the oath report or the date of the comment that's being responded to. I mean, is it ever the case that somebody responds late and we just take it?
I think because the period of time is presently so short, 10
Okay,
days
right,
from
okay.
the issuance of the report recommendation by the OTLJ, that the practice of the council to the board has been to provide people with additional time.
Right.
But always to set a deadline. So
Okay.
usually the practice has been the report and recommendation has been issued, the council to the board sends a letter to each party saying, please provide me with comments to the board by X date, and that date is usually longer than the rule actually permit. Which I think is, it's always better if we can have it codified
Okay.
in a rule. And then I think by providing this a longer, significantly longer period of time, that then we should be strict about it.
Okay.
You have now a much longer period of time to respond, but that really is the rule.
Okay. And then finally, on the final review, we kind of have our own internal procedures as to what happens when the presentation matters are presented to the board in terms of who's in the room, who leaves the room, et cetera. This doesn't discuss that. Maybe it's appropriate that it does not discuss that, but I just wanted to point out that it doesn't discuss that.
Wait, say that
In
again?
other words, when an oth matter has been presented to us for review, some members of our staff have to leave
Oh, right,
as a part of our own process.
and that's not.
And it's not in the rule.
Right.
And I don't know whether maybe it relates to the conversation we had a minute ago about ex parte, but it's not ex parte at that point. I'm not sure what I would call it. And it's about the separation of the prosecutorial function and the adjudicative function. And I'm wondering it's our practice, and one question is whether it should be codified.
Yeah, I think it is ex parte
It
because
is?
the other party's not
Right.
present.
Okay,
but,
okay.
But I'm not opposed to adding some language and trying to make that a little bit clearer.
I mean, in this context, it's particularly in the fact it's in the final review setting.
I might just add something to section, to page 18, line 6 to 16,
Okay.
something in there.
Okay, that sounds fine to me, but it just hit me that we have a very distinct procedure, and it's not alluded to here. So maybe if you put the reference to how the final review occurs in the ex parte side, that's fine.
Or just reference that section,
Yeah.
including
Right,
during,
you
or
could, that's
something
right,
like that.
yeah, that makes sense to me also, again, not to wordsmith it here. So that was 20. On 21, my real question is on line 10 about orders the board will be made public. The board may also make the report public as part of its order. May versus shall is really my question. Wouldn't we generally want to make the report public, or is there reasons to keep it may?
It's possible, so one of the things that can happen in a report and recommendation is that the ALJ can come to the conclusion that one of the charges was not sustained by the enforcement, by the prosecuting counsel. And I can imagine a circumstance where maybe something, some charge that was not sustained is, would create such a stir that it seems unfair to that person, or it contains private information in some way that would make that person, it would be unfair to that person to make that public. And I think that this preserves the board's ability to choose not to do that in that case. That's sort of my thought behind that.
It is true that our orders are usually fairly detailed. That is to say, our order usually has an explanation, or always has an explanation and reasoning, which often cites from and summarizes the oath report. So it's not like our order is not just affirmed or denied, but it's usually several pages long and summarizing the whole history of the case.
Right. There might be some reason to reduce the length of our orders and how much we say in them, but we wouldn't be precluded from doing that. So if we left a report and recommendation off in a case, we could certainly expand what we say in the order to address whatever it is we felt like. That's the board's opportunity to say publicly whatever it feels like it needs to say about it.
Do we typically make the oath report public, or do we typically not, or is there no?
I believe we have always made the report recommendation.
I was wondering whether about may versus shall, but maybe it does give us the
Doesn't
discretion.
OAT publish their reports online?
Those reports are confidential under the same charter section as the rest.
The oath report?
Yeah, well, actually, under the confidentiality of enforcement proceedings, pardon me, a different charter section, but those report and recommendations are confidential. The only way that they're becoming public is we're making them part of the document that is the board's order.
So OAT does not put these online?
It does not.
Because I know we have that issue with police, for example, where they were publishing them, and the police objected to it on the basis of that civil rights law section 50, which prevents police disciplinary records from becoming public. I know there was litigation over that, so I thought they published as a matter of course.
They do not publish, they do not even put on their public calendar when there are COIB enforcement cases. It's an entirely confidential proceeding.
So they make that exception for COIB cases because COIB is...
The charter requires it, yeah.
Okay.
Sorry to but my understanding is that a respondent can waive that if the respondent so chooses at oath, and if the respondent does that, then oath will immediately publish its report and recommendation at the conclusion of the proceedings. But that's an exception to oath's general policy.
And I don't think that's actually ever happened.
It has happened.
Well, it has happened in the case, though.
Right?
Anything else that would take us up into the middle of page 22, after which it's all deletions?
I have a question, or just want to confirm something. That's a change, and it relates to that same page 21, line 10. All orders of the board will be made public. And then I know in the previous or the current version of the rule, it says, I don't know that it says that, but it says it calls the dismissals an order as well, and it looks like we've changed that.
Yes.
Okay.
That was intentional,
Right.
because the board order is the public document when the board has found a violation.
Okay.
A dismissal is therefore not an order because.
Well, they were
it's
calling
not
it an
made
order dismissing the petition, and that would not be public, so we purposely changed it, so it's not even an order, and then we can say
Right, because all orders are made public.
conclusively all orders, period. And then this decision or finding, whatever it is, dismissing is not, but it's not an order.
Yes.
Gotcha.
Yeah.
Okay.
Should there be anything in here about hardship procedures? Do entertain that when we recommend a penalty and there's a respondent is unable or raises the issue of unable to pay the full amount? Should we recognize that in the rules somewhere?
Do we have a separate section on penalties? I mean, this is about the process.
This is about the process. We don't talk about how the board achieves its penalties.
Is there a rule on that anywhere?
No. No, the hardship process that the board has is informal, and it's very unique. Most city agencies that impose fines do not care about whether someone can pay that penalty or not. So I would be reluctant for the board to in any way formalize what that hardship process consists of.
Or I would think, to Jeff's point, if it was there, it would be in a penalties section. So since we don't have that here, I don't know where that would go.
The penalties that are available to the board are really clearly enumerated in the city charter.
Right.
Yeah, I would hold that off, and maybe there's another place in our rules where, if we want to think about it, we can put it in, but I think this is about the process of adjudication, rather than the post-adjudication. So I think there may be a case for having a rule on that somewhere in our rules, but I'm not sure it would be in this. Well, let's put that on some future agenda. That's a good idea, but I think this may not be the right place for it. Catherine, give us, I know I always ask this at this point, but if you could give us a recap of what happened. Once this meeting is done, and presuming that we're gonna, I'm guessing that we're gonna move forward with the idea of a handful of amendments, which I'll try and recap in a second, what's the next step?
So, sorry, just the next step is because we're gonna have to fix some of the language.
We're gonna come back to
Which
it. Right, and
I
then-
would expect to do at the next board.
And then after that, assuming at the next board meeting, we say, great, all done, what happens after that again, just to recap?
Then it goes to the law department and the mayor's office for review.
And then ultimately, there's a public hearing.
Right, assuming that there aren't any substantive changes in that formal
Okay.
review process, then we would schedule a public hearing and notice and.
Yeah, it'll come back to the board.
Oh, sorry, yes,
Even if
right,
there's a
even if
sing-
there's no, right.
Right,
Sorry.
it's only if there's not a single change, but if there's any changes from the mayor's office of operations and the law department, it will come back to the board will authorize us to put it forward to a public hearing, and then we'll schedule the hearing.
Okay, so if I were to ask us to approve this with modifications as discussed, we see it again.
Well, I
Yes,
think,
because-
right.
We
I
have
mean,
to
I
see the
think-
modifications.
Yes, yeah.
Okay,
Right,
okay,
right.
okay, right.
Didn't
okay.
come up with the exact language.
Right, okay. So my recap, my running commentary, or my running capping of this, if somebody will correct me, is I have 6 things. Some discussion in the commentary about the existence of private warning letters, no capitals. Some addition to the language, to the respondent's response, some reference to the ability to make a legal argument, as opposed to one about the facts. Some modest modification about concerning deference to the public servants agency's proceedings to give us the option of not waiting till the end. Some modification of the settlement offer language to make it slightly broader, to include admissions in that process, the banning of the use of that in the formal hearing, and 2 references concerning ex parte communications. One is Jeff's point about when the board says, if necessary, that's clear that's the board deciding it's necessary. And the other is to pick up that it applies to the final hearing before the board, like cross-referencing, but it was cross-referencing of C and I. Those were the 6 that I had. I don't know if I missed anything.
That's it.
Okay. Okay, well, I now call for a motion that the board adopt the recommended amendments to Board Rule Chapter 2 as the final rule with the modifications that the 6 modifications that I just mentioned, one of which only actually applies to the commentary, the other 5 are to the rules. Do I have a motion?
So moved.
Do I have a second?
Second.
All those in favor?
Aye.
Any opposed? Okay, well then the motion for adoption of these proposed amendments with the modification as discussed has passed. Take a deep breath and move on to the next set of proposed amendments. Okay, so we now have before us proposed amendments to Board Rule Section 1-14, which deals with official fundraising. We have sort of, in effect, we have this in two versions. One is Exhibit 4, which has the commentary and the proposed rule. I thought there was, and Exhibit 5, which is the pure rule. Let's work from Exhibit 4. It's one thing, the lines are easier to follow. It's a little easier to read. And we also do have the benefit of the commentary. Chris, I'm not going to ask you to give us an introduction. I think we're pretty well, we've been on these issues a lot in recent meetings, so I think we come into this pretty educated about the background, and I think also we have a sense that this is primarily designed to integrate our two leading advisory opinions on this, plus the consequences of the new chapter dealing with affiliated not-for-profits.
Yes.
Is that fair?
That's absolutely
I want to cut
fair.
you off completely. Is there anything more that you want to give us as a stage setting before we sort of jump right in?
No, basically this is, not only, codifying those advisory opinions, and this is sort of in response to the new charter section 2603C4 that requires the board to engage in rulemaking that codifies advisory opinions that have interpretive value beyond the individual public servant or public servants asking for them. And so this is consistent with that mandate.
Okay, so consistent with prior practice, either I'd like to begin with general comments about the whole thing and maybe anything about the commentary. Hold off for 1 second, the text of the rule itself, and if there isn't any, okay.
I just have one minor point in the commentary. On page 4, lines 8 and 9, when we go right into paragraph A1, we want to identify the rule. It's Rule 1-14, right?
Yes.
Yeah, just to provide context, because I don't
Absolutely.
think it's mentioned earlier, so just to provide people exactly
Yes.
what rule we're amending, that's all.
Thank you.
That's all I had on the
Okay,
commentary.
so again, anything, general concepts or anything on the commentary? And then the rule, the text begins on page 8. So why don't we turn to page 8? And then page 9. So on page 9, line 5, solicitation is directed either to the general public or to an individual. Does general public need more definition here? I know it's, in some earlier versions of this, in the advisory opinions, we had, I think at various times we had some language about using kind of numbers when something went beyond narrow and broad. Or maybe the flip side is there's something that we have a definition of targeted. I know in the past, I think one or the other of the advisory opinions where this would be codifying, I think we had some definition of what a targeted solicitation is.
Yes, so we did, in drafting this, staff did go back and forth about different ways to codify this idea that you are, that the solicitation is some sort of mass solicitation, that it's not, I think we wanted to get away from the word targeted, and so we use general public as sort of the proxy for this untargeted solicitation, where it's a mass solicitation that is provided, just on a radio broadcast, in a public service announcement, an internet, page on the web, on the organization's website.
What if it's just to Brooklyn? Or what if it's just to Flatbush?
I think that would be
Well, what if
general.
it's
That's general.
Okay, well, that's
I
what I'm
think
just
so.
saying, but that's what's not clear to me.
Okay.
As to whether or not all of Flatbush or all of a 6-block neighborhood. I get it, but I just wonder whether this might benefit from a definition of general public, which is inevitably going to turn into not narrow or something. So I'm not sure. Anybody agree with me? Or we think the general public is sufficiently
I
self-evident?
think general
We should leave it
public
alone?
is pretty,
Okay.
well, and I don't know if this
Yes,
is
and
incorrect, I
that-
see specific individual or firm or general public.
Mhm.
Okay.
I don't see whether it's to, a block, if there's only one block in one particular neighborhood, it's still general public versus
Yeah.
specific.
So general public and individual firm are together make the universe.
That's what I
If it's
would
not an
say.
individual firm, it's the general public. And that's clear to everybody, because just want to make sure, it's mostly about clarity. If that's,
Yeah.
if you think that would be, it'll be generally read that way, that it's either in one
General
or the
specific.
other, then I think it's safe.
Yes, and that's our idea in making that distinction as well.
Okay.
More on that page, we talk about the, you can't have a matter before the employee or the public servant where there is a matter before him or her.
Yes.
But should we say agency rather than just the individual?
That's not, so the advisory opinion refers to the individual public servant who is making the solicitation, and so we used that concept here. Certainly, the board could choose a broader rule, but we have we've used the same standard that the advisory opinion would articulate.
This is that we're writing a rule now, so.
Yes.
so-
It's, I think as a practical matter, it's not, it would effectively, for like the Department of Education, a huge agency, preclude like almost all fundraising, because there's so many matters before DOE at every level. And also, I think it would even be hard for a regular like teacher to solicit, because they wouldn't necessarily have a full idea. So just, right, each person knows what matters are before him or her, and that's the coercive concern the board's fundraising jurisprudence has been concerned about.
Going back up to lines 7 and 8 about the disclaimer,
Yes.
it's not clear to me that the disclaimer applies to subsection B. In other words, subsection A is in effect solicitations on behalf of city agencies or Chapter 9 nonprofits. But then subsection B authorizes solicitations for other nonprofits, right? But the disclaimer provision that it's not going to affect business with the city only applies to the solicitations for the city agencies and the Chapter 9 nonprofits. Shouldn't it also apply to any solicitation?
Yes, and I believe the rule does that. Romanet 4 at the very top, lines 1 through 4,
Right.
incorporates paragraph B
Okay.
into the permissible
Okay.
universe of
Okay.
permissible organizations.
Okay. Okay. And presumably then the provider of public service not associated language in Romanet 4 picks up the language in the commentary about you shouldn't be soliciting any entity with which you have any affiliation.
Yes.
Okay. And you don't need it for the others because the others they're all city.
They're all city,
Or
yes.
affiliated nonprofits. Okay.
Yes.
So this would apply, it applies to the city, it applies to the affiliated nonprofits under the
Yes.
section. And then it applies to others who have some nexus to the city if designated by the agency.
That's right.
head.
So for instance, like the Red Cross, something that's not affiliated with the agency, but there could be some benefit to the city for the solicitations.
And the agency head has to designate that in writing.
Yes.
Should we say designate it before the solicitation takes place? Prior to soliciting, there should be a designation.
Well,
So that's just procedural.
Well, that's
Yes.
in the rule,
Is there-
because it's, right, because essentially a solicitation can only be made for a not-for-profit designated by the public service agency head. So that's like, if you're looking at your bucket of potential sources, it's only one of those buckets, and only a designated not-for-profit.
No, I agree with that. I just wonder whether that designation should be made before that solicitation. If you think that's implied, that's.
Oh, I think it's clear
Yeah.
that you can only use it for a not-for-profit designated. And the designation has to happen pursuant to section B.
Yes, that's certainly been our
Should
intent.
those designations be filed with us?
So they will be, but not prior to. They will be pursuant to paragraph C2, and that's at the annual reporting.
Just to pick up on Carolyn's point, so this authorizes official fundraising for certain entities and under certain conditions. Is there what's the charter ban on a fundraising that doesn't fall within this? In other words, this is authorizing something that's otherwise prohibited. How or where is it otherwise prohibited, just for completion's sake?
Right, so you can only use your city position for a city purpose.
Okay, so it's the use of position, right, okay, got it. So otherwise it would be an improper use of position.
Right.
So this is an exception to that
Right, so
general
right,
ban.
we're
Got it,
saying
got it.
we're sort of putting
Got
a,
it,
yeah,
got
okay.
Just completion. This regulates how it's done, but if it doesn't fall within this, it would violate the charter otherwise.
Yes.
Got it. Anything else?
Couple quick questions.
Yes.
Line 12,
Okay.
the term of our clear and direct nexus, does that come from
You're
the
on,
AA?
I'm sorry, page
I'm
9.
sorry,
Page
I'm
nine.
page 9.
So it is, let's see, if not directly, substantially similar to the discussion in 2008-6.
Okay, so it's from that AO.
It's from that AO,
Okay.
yes.
Because it also looks similar to some other, like, maybe some language we're using in the Chapter 9 context as well.
Yes, no, but it is from
Right.
2008-6, and it's not, it's sort of condensing a couple of paragraphs into a line, and so it takes all of the concepts that are in there, the clear and direct nexus, not only to the city, but also to the city agency that's involved. So for instance, one agency, the DOE, there has to be some connection to schools and education for the fundraising to occur, not for some other purpose. But all of these concepts are taken from the advisory opinion.
Okay. And then, one point in subsection C,
Okay.
the non-disclosure, failure to comply with the disclosure is subject to a fine under 2606D.
Yes.
Right. Do we want to make that clear in the rule? Just throwing that out there, Richard, I don't know. If we want to we make it clear in the commentary, but I don't think we make it clear in the rule.
I don't think in any of our other rules we necessarily point people to 2606 for the penalty section. I mean, it's clear that you'd be violating B2 here, and B2 has a penalty when the rules apply.
So that's sufficient notice for reference to B2.
I
I think so. I'm just throwing it out there because in the commentary we made it clear, but we don't have it in the rule itself.
Right, B2 is just the one provision in chapter 68 that doesn't have a penalty unless there's a rule.
Right.
But that's made very clear in the city charter that in 2606D, if there's a rule under B2, then it's penalizable just like any other part of the city charter, of the chapter 68.
All right, that's it.
Anything else? So my count, we have this one very minor revision to the commentary, the very opening of the commentary, which I'm not going to treat as a modification requiring return to us.
Ministerial.
Okay.
It seems to me
Yeah.
that's a fairly extremely modest stylistic change. So having no further discussion, I'm going to call for a motion that the board adopt the recommended amendment to Board Rule Section 1-14 as the final rule. Do I have a motion?
So moved.
Do I have a second?
Second.
All in favor?
Aye.
Any opposed? The motion for adoption of proposed amendments as presented as the final rule carries. There being no further business for consideration pursuant to the open meetings law, this meeting is hereby adjourned.